Yeah, doing that.
Okay, let's see. Lyle Allen is here.
Yes, I'm here.
Okay.
Yeah, Jared.
Oh, there he is. I thought he was on. I just asked him. Okay. On the record in the matter of the people of the state of Michigan versus Lyle Allen, file number 23-00156. Council appearance.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Allen. He appears with us today remotely from the Ingham County Jail.
Okay, great. Today is the date set for sentencing. We have a pre-sentence report. Appear back on May 15, 2023. Did you get a copy of that?
I did, Your Honor. I sent that to Mr. Allen at the time.
Okay, very good. Do we need to make any corrections, updates, or deletions?
Probably the only update as far as I can see, Your Honor, is it does have him listed as employed, although that was probably accurate at the time. I think Mr. Allen, while he tells me he's going to be obtaining different employment once he's released from jail, it's probably no longer working at that place, but it was accurate at the time that it was done.
Okay. No other corrections or updates?
I would just update the court on Mr. Allen's matter at 55th District Court, Your Honor. He's currently in custody there on that. He does have a cash surety bond, although that is to convert to a personal recognizance bond today. So I anticipate he'll be released on that file today. He is set for sentencing at the end of this month on that file, where it's anticipated that he's going to be placed on probation in that court.
Very good. You can proceed to allocation.
Yes, thank you, Your Honor. Your Honor, Mr. Allen's prior criminal history is rather limited. He has no prior felony convictions, nothing violent or assaultive. And any prior convictions that he had, Your Honor, up until these current matters were over 10 years ago, and almost all of them seem to involve alcohol or controlled substances, which obviously Mr. Allen struggles with. He also has some mental health issues, as well as some physical issues. Hopefully he'll be able to get a lot of help and treatment and rehabilitative services that he needs out of the 55th District Court. I have talked to him about that. Once he is released, he is going to be set up on one-on-one counseling where he can address both his substance abuse and mental health issues. And then he'll be attending 12-step meetings multiple times a week. They'll be having him do some form of drug and alcohol testing. He believes that Medicaid will pay for that, so that's not an issue. He doesn't currently have a driver's license, so that may cause him some issues in terms of transportation. But Mr. Allen, informs me that he's working on that and making provisions for that as well. Given that he's going to be supervised in at least one court, Your Honor, I would ask if the court is inclined to place him on probation in this court, that there essentially not be any doubling up on either testing or services. If the court or the probation department orders him to do something here, he's doing either the same or similar thing out of the 55th District Court. I would just ask that counts, so that he's not essentially doing twice of the same thing in two different locations. I don't think an additional jail sentence is necessarily needed for Mr. Allen. I think he does need help, and hopefully he'll get the help that he needs and engage in those rehabilitative services on probation, either here or at the 55th District Court, or a combination of the two. And I would ask the court to sentence him accordingly. Thank you.
Okay. So as it stands, he's not been sentenced to 55th.
Correct.
Okay.
That is set for the end of this month, I believe, on the 31st.
Okay, and then in addition to that, what is the charge that he's being sentenced on over there?
I believe it is some type of drunken disorderly, something of that nature, Your Honor.
This is a far more serious crime than that. So they would need to comply with our order if that's what they want to do. He's going to be placed on a term of probation before this court because in this matter, we have a substance issue or a perceived substance abuse issue. I don't have where he ever complied with my order to get an assessment done. And it looks like the author of this report did try to make contact with him. I think he was supposed to have an appointment with Crystal Ray. Was that ever done?
Not to my knowledge, Your Honor, from speaking with Mr. Allen this morning, is that in whatever coordination he's been doing out at 55th District Court in preparation for sentencing at the end of this month, he is to report to Crystal Ray for them as well as soon as he is released so that he can get that assessment complete. He is to follow any and all directives of that assessment.
Okay, did your client wish to make a statement at all?
Mr. Allen, do you wish to say anything prior to sentencing?
Yes. Hello, Your Honor. I'd like to start out by apologizing to you and the courts and City of Lansing and anybody involved, everyone involved, for missing my court date and not getting the assessment done immediately. I did talk to Crystal Ray, and at the same time, between doing that, because I had to do the same thing for Judge Allen, 55th. The two cases together, I got messed up on them, and since I've been sitting down and waiting for this day to come, I've had a lot of time to think about it. I've had a lot of, gotten 24 days of clean time, and come to realize that a lot of my biggest problem in life is I'm dependent on other people and other ways of transportation and doing this and that. And at 51 years old, I think it's time that I start moving forward in life with my driver's license, so to speak, because I haven't had one in over 20 years. And I tend to just fall short. And that's because I choose to drink instead of trying to put forth some effort on better in my life, because I have some mental concerns that are going on, and I've been dealing with that. But I really did attempt to do the assessment with Crystal Ray on your behalf and Judge Allen's behalf. And I did make it to that point. One thing led to another, and then, here I am. But I do want to try to complete probation, get this behind me. But at the same time, the reasoning is because I believe that now is the time for me to actually take advantage of this opportunity to actually get my license back, prove I can stay clean and sober, and I'm worthy of being able to drive again in the United States, in Lansing, Michigan. And once again, I do apologize for messing up, but I have learned my lesson thus far.
Thank you. Okay, so I reviewed your pre-sentence report, which again is limited because we didn't have an assessment. And then your prior criminal history, as indicated by your attorney on the record, there's no felony convictions. You've had a couple of issues with operating while intoxicated, so it does indicate to me, in addition to this charge and the charge that you've got pending for sentencing before 55th, that there's something going on as it relates to substances, and it would be best addressed through a term of probation at this time. So I will adopt the recommendation. The sentence will be 365 days Ingham County Jail with credit for time served. Let's see, I think it previously had time from January 18th to January 23rd, but you since it looks like been in custody since the 15th of June. Did he go into custody on the 14th and arraigned on the 15th?
He was arraigned on the 15th, Your Honor, so I would say that's probably likely accurate.
Oh, sorry. Say 14 until today. Guess I'm not giving credit for 9 days. I'm gonna- 33 days. Okay, okay, and the balance of that time will be suspended upon successful completion of a 12-month period of probation. While on probation, sir, you're not to use, purchase, or possess alcohol, marijuana, or any controlled substance that you do not have a valid prescription for. Do you understand that?
Yes, Your Honor.
You will be required to submit to random preliminary breath testing and or urinalysis testing. You're responsible for the cost of that, okay?
Yes, Your Honor.
Okay, I'm gonna order that you complete your substance abuse assessment with Crystal Ray. That needs to be provided to probation, so you'll have to sign a waiver so that it can be sent over to them, okay?
Okay,
You'll be ordered to follow all the treatment recommendations from probation following the receipt of your assessment, okay?
yes, Your Honor. Okay,
Did you say he was already attending a 12-step program?
He is going to be ordered to once he is released, I think, as part of his bond and anticipated probation out there. Don't know that
Okay,
he's engaging in that currently, but that's my understanding from speaking with him. That's what they're going to have him do.
Okay, because I'm ordering a 12-step meeting as well, but obviously you don't need to do that twice. So you'll just need to provide verification that you're doing that. So if you're doing that at 55th, you'll provide verification of that to your probation officer here at 54A, okay?
yes, Your Honor, okay.
Okay, once you're released, you need to maintain or obtain and maintain employment and provide verification of that to probation. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to be at any bars or nightclubs while on a period of probation. Do you understand that?
Yes, Your Honor.
There's a $30 per month oversight fee that you would be responsible for being on probation. So that's $360. I'm gonna waive discretionary fines and costs. However, there is a $75 crime victim rights fee that must be assessed per statute, and a state minimum cost that also must be assessed.
Okay,
So that's a total of $485, but you'll be making monthly payments on that, okay?
okay, thank you, Your Honor.
About $40 per month, not including the cost you'll accrue for testing. Do you have any questions about your fines and costs?
I do not. Only thing I have a question about is the testing. Where do I do that at? How does that work? And the other probation officer I spoke to, Ms. Lopez, in 55th, suggested Medicaid would help me, and I know you suggested I do it, or said that I have to do it. I understand that. I just have any idea how much that costs, or how many times a week I'm gonna be tested, or how that works?
You can discuss that with your probation officer, and they can work with you. There's no need for you to test for both here and 55th. So if you're going through testing in 55th and you have not been sentenced yet, but we're expecting that that's what's gonna happen. And there's a way for that to be covered through Medicaid, then they'll make sure we work that out. We'll just receive those results, okay?
Okay, so in the meantime, do I just talk to my probation officer through your district court about my testing? Like, do I start testing next week or immediately? I mean, I just wanna make sure.
So what will happen is you'll be in contact with our probation. They have to go over my order and then you'll sign it. And so that'll be your opportunity to discuss the particulars as to your testing and your ability to test and have that covered through your health insurance, okay?
Okay, thank you.
No problem. Lastly, I do have here an advice of rights as it relates to probation, and it states here that you have the right to request early discharge from probation once you've completed half the original term ordered by the court. So that would be 6 months in this case. You must have completed all of the probation program requirements, and you must not have had any violations within the 3 months prior to your request. Do you understand that?
Yes, Your Honor.
You can make that request by getting the MC 512 form, which is on the court website, or you can get that form from your probation officer. You would complete that form, you'll file a copy with your probation officer, but you'll also need to serve a copy on the prosecuting attorney. The prosecutor's office will have an opportunity to respond within 14 days of receipt of your request. Do you understand that?
Yes, Your Honor, I just have to make sure it's after 6 months before I submit it. Is that correct?
That is correct.
Okay,
And
thank
you
you, Your
can't
Honor.
have any violations within the 90 days prior to that, okay?
Yes, Your Honor.
Okay, then also in addition to that, if there's a hearing that's set to address your request, you have the right to hire an attorney to represent you at that hearing, but you do not have the right to a court-appointed counsel for that purpose, okay?
Okay,
Do you have any questions about your rights as it relates to early discharge?
I do not.
Okay, any additional matters for the record, counsel?
I have nothing additional on behalf of Mr. Allen, Your Honor. Thank you.
Okay, thank you, Mr. Allen, and good luck to you.
Thank you, Your Honor. You have a good day. Thank you again. And I apologize again.
Thank you.
Thank you.
No problem.
All right. Oh, Your Honor? Your Honor?
Yes, sir. Yes.
Just to kind of ease some pressure off me real quick, through my experience being here in the last 24 days, I guess I'm supposed to wait for some paperwork from you guys saying it's okay for me to go home today and to be on a PR from the other court. I understand that's not your part as far as a PR, but what we've experienced some of our inmates here, or my fellow inmates in here, the court papers aren't going to where they're supposed to. And guys are sitting here up to 2 or 3. One guy was here 2 to 3 weeks after because the paperwork wasn't shown. With all due respect, ma'am, could you please help me be reassured that my paperwork gets sent over today so I can go home and start all over again?
Paperwork from our court will be completed today. Our clerk's office will ensure of that. You're not being held on this in jail, so I can't speak to what's going on at 55th though, okay?
Not a problem. I certainly understand. Thank you.
But as it relates to this case, you'll be released in our system today, okay?
All right. Thank you, Your Honor.
You're welcome. Thank you. Have a good one. Who was representing Hayward? Abdi. Okay, so he did speak to him before, I assume? Yeah, is that Plea?
He told me it was gonna be a plea. He wanted to go over the offer with him when he got here, but he's not.
Is Goldie Sapp still?
Is it okay to leave the courtroom, Your Honor?
Yes, yes, sir. You're free to go.
Okay, thank you, Your Honor. You have a good day.
Same to you, sir. No, that's awesome. Gosh. Thank you.
After it's on record, Flores, he represents Johnson with a felony, but he does have to now public PD arraignment.
The PCC document. Okay, here we go. Okay. Clover? Oh, Clower, that is,
The attorney's office.
okay. Sounds good. We're on the record in the matter of the people of the state of Michigan versus Cody Clower. File number is 23-01846. Council appearance.
Thank you, Your Honor. Dale Coltrane appearing on behalf of the people.
Good morning, Your Honor. May it please the court, Nathan Collison appearing this morning on behalf of Mr. Clower, who is present via Zoom, and Mr. Clower does consent to proceed remotely via Zoom.
I hope he did, because he appeared remotely, he could have appeared in person.
This
Mr.
is
Clower, it was not mandated to appear via Zoom. Mr. Clower, can you hear us? I can't hear you.
Mr. Clower, you need to unmute yourself. Muted.
I don't know how to unmute myself.
You've done it. We can hear you now.
Okay.
Okay, very good. Today is the date and the time that was set for a probable cause conference. My understanding is that we are looking for a waiver of the timeline today.
That is correct, Your Honor. After discussions with the defense counsel, it's my understanding there would be a waiver of the 21 days today by his client. There would be two reasons for that. One, I believe Mr. Clower has other matters pending between here and East Lansing. We would like to discuss all those matters as possibly a package deal. And also, I just want to make sure that Mr. Clower's attorney has all of the discovery needs in this case.
That's correct, Your Honor. I've explained to Mr. Clower his rights regarding a preliminary examination within 21 days of his arraignment. At this time, he's
Your Honor,
prepared.
we would request a couple of weeks adjournment just because Mr. Clower has other counsel representing him in East Lansing on those matters from the public defender's office.
Okay. Mr. Carlson?
Correct, Your Honor. I am also I'm awaiting discovery, which I've been assured is going to be forthcoming, and the representation is made by brother counsel accurate regarding our conversation yesterday.
Okay, very good. Okay, Mr. Clower, you understand that you have the right to have a preliminary examination in this matter within 21 days of the date of your arraignment?
Yes, Your Honor.
Okay, and under the circumstances in which you have another matter pending in East Lansing or in 54B District Court, in which parties are seeking a global resolution, and in this matter, you still have some pending discovery. Are you seeking or willing to waive your 21-day timeline so that we can reset this matter?
Yes, Your Honor.
Is anybody threatening you or forcing you to waive your 21-day timeline?
No, Your Honor.
Blue chair, I see right on the screen.
July 27th. Does July 27th at 10:30 work?
Yes, Your Honor.
Well, that was for the attorney.
One moment, Judge. That should work just fine.
Okay, so we'll let me do this. Let's treat the 14th as a new PCC because I want to make sure discovery is all set. So I don't want to come July 27th and then we still have discovery issues. And then July 27th will be the PE date. Okay, any additional matters for the record today?
Not from the people, Your Honor.
Nothing on behalf of defendant other than what time on the 27th, Judge?
It's 10:30.
Excellent. Thank you very much.
No problem. You have a good one.
Thank you. You too.
Michael Wallace and Mr. Abbott.
You're all set, Mr. Clower.
Thank you.
Sounds good. Mr. Abbott's not here. Though. Okay, and think that's Mr. Etheridge's, right? Who's in the jail with the bald head?
Wallace.
Thank you. That's Mr. Wallace. Mr. Goodrich, do you have someone here?
Mr. Abdi is right here on a pre-CC and Mr. Melton is in the hallway, ready for a sentencing.
Okay, Mr. Melton can come in. Okay, we're on the record in the matter of the people of the state of Michigan versus Daniel Melton, file number 22-00598, FY, council appearance.
Attorney Luke Goodrich from the Public Defender's Office filling in for Sarah Donnelly today, representing Mr. Melton.
How are you, Mr. Melton?
All right,
I'm sorry?
good.
Oh. Today is the date and time that's set for a sentencing. I do have a pre-sentence report that was prepared back on June 30th. Did you get a copy of that?
Yes, we did.
Okay, and you reviewed that with Mr. Melton.
Yes.
You need to make updates, corrections, or deletions.
No.
Okay, you can make allocation.
Thank you, Your Honor, this week, Mr. Melton, like I said, to this day, he's still not sure why he kind of chose to grab the woman's purse in that situation. He's been homeless quite often. He currently is at the moment. He does go to CMH every 3 weeks, so he's been getting treatment for his mental health issues to help prevent these type of incidents from occurring. He hasn't had any incidents like this since this occurred in late February. So he has had 4 months or so of doing well. Especially the victim did get all of her property back after another gentleman intervened and stopped Mr. Melton, and he was arrested soon thereafter. He does get by on disability payments to help fund, the food. And hopefully, he'll be able to use that to get a shelter. And he had an agreement, I guess, with his brother that where he was staying with him for a little while, and that fell through. So he's kind of back in that transition of working on getting another place to stay. He told me that he'd like to do probation. Hopefully, probation might be able to help him get some of those services that he needs to get into more stable housing center. So we would ask the court to follow the recommendations here of the 6-month term of probation. I think that fits the offense well. He's willing to do community service if the court orders that as well. So we would just ask the court to follow the recommendations here.
Okay. Okay, Mr. Melton. I've reviewed the report and your prior criminal history. I don't see anything of this nature on your prior criminal history. I do, however, have a concern that based on your admission as to some diagnoses that you had, that you've not been consistently taking your medication. How are you doing with your medication now?
I haven't been taking my medication. I'm going to go back on the see if I can get it.
Okay, so why haven't you been taking it?
I don't know, I just haven't been taking it. I just want to see if there's any difference in me not taking it when I do take it.
Are you doing a scientific experiment by not taking it?
Yeah, something like that.
Who told you to do that?
Myself.
Okay, well, you stated to our probation department that you believe that you acted in the nature that you did at the time of this incident because you were not taking your medication.
Yeah, but then I was taking my medication again. I thought I didn't see no difference when I'm taking them and I don't take it.
So you stop taking to see if you do something bad again? Is that what's going on?
No, not bad, it's just, I don't know.
What is your alternative measure for addressing your issues without your medication? What was you doing other than taking medication? What is your plan?
Get a job and,
But not be on your medication?
yeah. Just to get a job and see if I can go without my medication.
Okay. Did you get a doctor to approve you not being on medication?
No, I didn't, but I want, I just don't feel any different than when I'm on medication.
Okay, okay. I know you probably don't feel any different, but there's a reason why when you have a diagnosis as serious as schizophrenia that they're giving you medication to take. You understand that?
Yeah,
Okay, and so you don't get to decide that you don't want to take that medication and that you feel the same way. You need to have a doctor evaluate that and make that decision for you, okay?
okay.
You need a medical professional to do that. So what I'm going to do, because my concern is that if you're not on your medication, you may continue or create to do actions like this or more serious actions. That's my concern, and we don't want that, sir. We want you to be stable so that you can get a job and then you can be a contributing member of society. I am going to adopt the recommendation, which is to place you on a term of probation. The first order is that you're going to report to community mental health. You're going to be compliant with all medical orders for your medication. You understand that?
Yeah.
You need to report to CMH immediately for that, okay?
Okay, I will.
Going to place you on a term of 6 months probation. In addition to making sure you take your medication during that time, unless a doctor gives an order otherwise, you need to make sure that you're not engaging in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. Do you understand that?
Yeah.
You're not to use or possess alcohol or drugs unless you have a valid prescription for the drug, okay? You will be required to submit to random preliminary breath testing and or urinalysis testing, okay?
Yes.
I'm going to order that you participate in serving 30 hours of community service within that 6 month period, okay?
Okay.
You can get a list from the probation department as to where you can do that, okay?
All right.
Do you have any questions at this time, sir?
No.
As to fines and costs, there is a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed. Probation has a $30 per month oversight fee that you're responsible for. So for 6 months of probation, that's $180. And you'll be able to make monthly payments on that, or if finances are an issue for you, we'll address that at the end of your probationary term, okay? Lastly, there is an advice of rights as to probation here. It says that you have been sentenced to a term of probation by the 54A District Court. So you have the following rights as it relates to that. You can request early discharge from probation after 3 months, okay? But you can't have any violations within that 3 months. Do you understand that? You would get the form from probation and you would file or complete it to request early discharge. You need to give a copy of that completed form to your probation officer and to the prosecuting attorney's office, okay? Prosecutor would have 14 days to respond to your request for early discharge. If I hold a hearing to address your request for early discharge, you have the right to hire an attorney, but you do not have the right to have a court-appointed attorney for that purpose, okay? Do you have any questions about that? Okay. Do you have any questions about your sentencing or your fines and costs?
No.
When you leave here, I need you to go down to the 5th floor and check in with probation, okay? Any additional matters for the record?
No, Your Honor.
Okay, you're all set. Thank you, sir. Mr. Abbott is here. Mr. Etheridge is here. For whom?
Johnson.
Recent those till next week. Okay, we're on the record in the matter of the people of the state of Michigan versus Michael Johnson, file number 23-01872.
If Your Honor, Dale Collier on behalf of the people.
Morning, Your Honor. Attorney Derek Esposito, above public defender on behalf of Mr. Johnson. I'm physically present in the courtroom. Mr. Johnson is appearing by Polycom from the Ingham County Jail.
Thank you. Today was the date that was set for probable cause conference. How are we proceeding?
Your Honor, it's my understanding, this case being handled by Ms. Gallagher from our office. An offer has been conveyed to the defense for a plea at district court level next week, time of preliminary examination. It would give everyone an opportunity to get the paperwork together. I could place the plea on the record today if you would like that.
Yes, please.
The offer being conveyed at this time would be the defendant would plead guilty to count 1, which is assault by strangulation, and count 4, which is the DV second. Then there is counts 5, 6, and 7. Those are all assault battery charges. The defendant could choose to plead to one of those. And then people would dismiss the remainder in the complaint. There would be a kilobreach of restitution on all counts originally in the charge and all victims. That would be determined at the time of sentencing. There's a kilobrew that the victim's rights would attach to all counts, even those being dismissed. Further, there would be a kilobrew to no more than 120 days upfront jail at the time of sentencing. And the people have also indicated to defense that a no contest plea would be acceptable also.
Mr. Etheridge.
That's a fair and accurate recitation of what the current plea offer is. Mr. Johnson is more than likely going to accept the offer. I am going to be corresponding, emailing Ms. Gallagher regarding a couple of issues. One primarily being the restitution to be determined. We would like to reserve a right to a hearing because we don't know the amount of the restitution at this time. But I think for the most part, everything else is acceptable by Mr. Johnson.
But the only other thing I would indicate for the record is I believe Ms. Gallagher's indicated that that plea offer would be rescinded at 2 o'clock the day prior to next week's court date, so that she can call out her witnesses. They have to come. She's going to hold it there.
That's indicated in the email I received, Your Honor. And it also indicates that she will proceed with or without victim participation.
Okay, sounds good. So that's been noted on the record. This matter is scheduled for preliminary examination on July 14th at 8:30 in the morning. And as indicated by the prosecutor, the offer will expire at 2 p.m. the day prior.
That's clear, Your Honor.
Okay,
But as I stated, it more than likely will be a plea at this point.
okay,
Just the one caveat that I want to clarify.
sounds good. Okay, any additional matters on this record today?
Not from the people, Your Honor.
Not from the defense, Your Honor.
Okay, do you have any questions, Mr. Johnson?
No, Your Honor.
Okay, you're all set for today. I've reset your other 2 matters until next week.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. Mr. Abbott, okay, we're on the record in the matter of the people of the state of Michigan versus Michael Scott Wallace. File number is 23-01930, council appearance.
Good morning, Your Honor. Elena Cisneros on behalf of the people.
Good morning, Your Honor. Attorney John Abbott representing Michael Wallace today. Dwayne Silverthorne's case, but I'll handle the PCC. Thank you.
Okay, today was the date and the time that was set for probable cause conference. This matter is scheduled for a preliminary examination next week, July 14th, 2023 at 8:30 in the morning. Are we continuing to exam?
Yes, Your Honor.
Any preliminary or matters that we should address today?
Your Honor, Mr. Wallace has asked me to address the issue of bond.
You can make a motion.
Thank you, Your Honor. Mr. Wallace is a 33-year resident of Lansing. He's lived at the same address for 10 years. He's had the same job for several months. He's got family here in town, including his children. I think the risk of flight is very low. The alleged victims in this case are family members and can be protected by a court order and a GPS tether. I'd ask the court to lower it's currently set at $100,000 cash surety. I'd ask the court to reduce the bond.
Mrs. Cisneros.
Thank you, Your Honor. I would ask that the court not reduce the bond and, if anything, hold off until the conclusion of the preliminary exam and the court is able to hear proofs. This defendant has 2 other matters, Your Honor, up at the circuit court level, one of which being for an assault, strangulation, and criminal sexual conduct, and the other one being for assault, strangulation, and felonious assault. That happened, this alleged case that is before Your Honor today happened while he was on bond in those 2 separate files. Given the alleged violent nature of all 3 of the cases that Mr. Wallace has open, I would ask that the court refrain from modifying the bond today.
Okay, I'm reviewing some information in the file that indicates why and how the bond was set at $100,000 cash surety with GPS tether, being an exclusion zone of 2,000 feet and victim notification. Based on the circumstances in this alleged matter, which count one of assault with intent to do great bodily harm less than murder or by strangulation, is a child abuse third degree, and there is a domestic violence. There's also a second offense notice here, and then it being out on bond with multiple cases pending in the circuit court. One of them being a CSC first degree, an unlawful imprisonment, a felonious assault, and an aggravated domestic violence. The court is inclined to believe that there is a serious threat to the public safety, but also to the alleged victim. And so because of that, I think the bond was appropriately set. Bond at 100,000 cash surety will continue. So your motion is denied. Any additional matters for today?
No, thank you, Your Honor.
No, Your Honor, thank you.
Okay, you're all set, sir. Thank you.
Thank you, Your Honor.
Who did you have?
Abdi, ABD.
On the record, I'm gonna move the jails, please. We're on the record in the matter of the people of the state of Michigan versus Marjan Osman Abdi, file number 23-02030, FY, council appearances.
Thank you, Your Honor. Dale Coltrane on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Abdi, who's standing to my right today.
How are you, Mr. Abdi? Well, thank you. Today is the date set for a probable cause conference. The matter is scheduled to proceed to preliminary examination July 14th at 9:30 in the morning. Are we continuing to exam?
Yes, Your Honor.
Okay. Let's see. How old are you, sir? Okay, sounds good. Any additional matters for the record?
From the people, Your Honor.
No, Your Honor.
Bond was set at 3,000 personal recognizance with a curfew from 10 PM to 7 AM unless you're working, and you must be residing at your mother's residence. You understand that? We've had any issues with that? Okay, any additional matters for? Okay,
Not from the defense.
you're all set. We'll see you next week, sir. Okay, did we see Kaylee Thibodeau? No. No? Did you speak to her?
So you have to see.
Hmm.
Fair enough.
Yep.
Well, okay, let me see here.
Thanks.
Thibodeau failed to appear. Okay, where's the jail with Mr. Abbott's other people?
So Williams is on a rip to Costa County. And we went there according to Ingham County as of June 30th.
Okay, so we have to reset that, or we'll treat next week as a PCC.
Can't do it.
We, oh, they can't put them on Zoom? No. There goes his 21 days. Let's see. Stephen Williams. Mr. Abbott, your client is in Mecosta County.
Stephen Williams, Your Honor? Yes.
Okay, so I find the cause to go beyond his 21 days because we can't rate him within that time frame.
Okay.
Thank you, Your Honor.
No problem.
I think we have Mr. Haywood, Mr. Abbott.
Is he here?
You already did a benchmark.
Oh, I did a bench warrant for Haywood. Mr. Abbott, you haven't been in contact with him, correct?
I spoke with him yesterday. I expected him to be here today, but he's not here.
Okay, so I issued a bench warrant. Okay. Is that all you have, Mr. Abbott? No, you have somebody else at 10. You're busy today, Mr. Abbott.
I have Douglas Warner, Your Honor, at 10.
Okay, sounds good. I'll see you at 10.
Thank you.
Thank you, Your Honor.
No problem. Okay, they're gonna put this B on or no?
Should be. On the power counts.
Is David Larson here?
That's one that we did over email yesterday.
Okay, we need his fingerprints. We need Clower's too, I think.
Yep.
Jail. What's your name, sir?
Bisby.
Okay. Mr. Etheridge needs to speak to him.
Yeah.
Let me see if your attorney needs to speak with you.
Yeah, they're having issues connecting. I'm gonna hang up. Just give me a couple minutes to shoot down and. Anybody up yet? Nothing yet?
You can be seated. You ready with, okay. Bisby. Got it. Mr. Goodrich is here for Larson.
Wimberley.
Hmm?
Wimberley.
Wimberley, is Wimberley here?
Supposed to be logging in.
Oh, sounds good. Mr. Abbott, do you have Mr. Goodrich?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Douglas Kirk Warner, file number 23-01484, FY council appearance.
Thank you, Honor. Dale Coltrane on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Warner. He's standing to my right.
Okay, Mr. Warner, today was the date that we reset your probable cause conference. Let's see. No, this is a preliminary examination. How are we proceeding?
We're ready to proceed.
Oh, okay.
Today is the exam. correct?
Today is the
People
exam.
cannot proceed at this time, Your Honor.
Okay. No witnesses has appeared. So how do you want to
Move to
proceed?
dismiss.
Oh, you don't want us to adjourn it?
Yeah.
Oh, okay. Okay, your motion is dismissed without prejudice is granted. That means that the case will be dismissed today. However, if the necessary witness appears later and they're ready to proceed within the statutory time period, the people do have the right to reissue the charge against you. Do you understand that? Do you have any questions? Okay, we'll get you a copy of your dismissal. You're all set, okay?
Thank you.
Thank you. You still in your new printer? Why not? Who we got to talk to? They said it's coming. Oh.
There's Flores. We're not here.
Okay, I see Mr. Vitale is here. Mr. Petey? Where's Miss Petey?
She's home with my granddaughter today.
Mm-mm. You get her on the phone and tell her to get here immediately. She's gonna stop tying up the court's time and then not appearing. It's supposed to be logging in from where? Mr. Goodrich,
Yes, Your Honor.
have you spoke to Mr. Larson already?
Yes, Mr. Larson, yes, I spoke with him yesterday.
Okay, so we're just continuing to exam, or did you need to go on the record for something?
With Mr. Larson, we were just continuing to exam. I do need
Okay,
to speak with Mr. Wimberley when he gets on.
Okay, sounds good. Thank you.
Okay.
Okay, it's Wimberley then. Is Wimberley in charge now? Yeah. Got it. Objection. Kayla Toma?
Hello.
Which matter are you here for?
Palisades Collection versus Ruby Bridgrove. Sorry. It's case number 064656 GCE.
Thank you. Okay, we'll get rid of those here.
Judge, I would like to just to let you know, while we're in the breakout room, the defendant stated that she believes that the case or the debt is fraud. So regardless, we're gonna probably have to go for an adjournment for 60 days. But I just wanted to give you a heads up before we get that on record and everything. And start discussing the case.
It's Mr. Kajer. Okay, we're on the record in the matter of Palisades Collection versus Ruby Abrego. File number is 06-04656 GC. Counsel, can I have your appearance?
Yeah, this is Kayla Toma, P number 86304 for plaintiff.
You and then Ms. Abrego, you can hear us clearly, correct?
Yes.
Okay, today was the date and time set for a hearing on an objection to garnishment order. The parties did meet privately, and as indicated by counsel for the plaintiff, there's a request for a 60-day adjournment.
Yes.
And that's for you to investigate the claim that this is a fraud.
Yes.
Mr. Kajer, I can't hear background noise in the courtroom, okay? Ms. Toma?
Yes, that's correct. 60-day adjournment.
September 7th. September 7th at what time? September 7th at 10 a.m.
That sounds good.
Thank you very much.
No problem. Any additional matters for the record today?
No.
No.
You're all set.
Okay, thank you. Thank you.
Thank you.
Okay. Okay. Okay, on the record in the matter of the people of the city of Lansing versus Devon Kajer, file number 21-02784. Mr. Kajer, today's the date that was set for show cause hearing, and that is because you owe a balance, looks like of $804.72. You saw the magistrate, Milmore, back on February 24th, and it stated that you were paying or making payments on another court order and that you were going to begin your payments on this one beginning in March, but it does not appear that we received any payments. What's your plan, sir? You're muted.
Can you hear me now?
Yes, sir.
Oh, I'm sorry about that. Yes, I had kind of got lost with it. Honestly, I forgot about it. Not to say that it's not important or anything, but I had other stuff I was paying too. But I can make my first payment on next Friday.
Okay, how much will that be for?
I will put 100 on it.
Okay, and when will you make your next payment?
Every other Friday from there. Like, try to keep it up with my work schedule.
Okay, I'll note here that you'll make a payment of $100 next Friday and that you'll make bi-weekly payments. That's of $100, correct?
Yes, and do I come into West, like downtown to pay that?
You can make payment here at City Hall on the 6th floor at the criminal traffic window, or you can do it online at the court website. You just use your case number, that's the 21-02784 number, or you can mail, check, or money order to the court and attach that number to it, okay?
Okay.
Do you have any questions at this time?
No, ma'am, I don't.
Okay, you're all set, sir.
Okay, thank you.
You're welcome. We're on the record in the matter of Joseph Vitale versus Michael Petey and Christy Petey, file number 22-04155 LT. Plaintiff, please state your name.
Joseph Vitale, Your Honor.
Okay, and sir, what's your name?
Michael Petey.
Okay, and then I have Miss Chrissy Petey here via Zoom. I'm gonna first discuss the matter. Miss Petey, this matter has been set multiple times, and I've given an exuberant amount of grace as it relates to resetting this to allow you to make your case. However, you have continued to fail to appear to court. There was at least one time where you contacted the clerk's office and said that you could not appear because you could not speak. But when I ordered you to appear the next day, you were able to speak. Then I reset the matter to allow you to get an inspection done. We set this matter for hearing. You failed to appear in court because you purportedly were in the hospital. This matter proceeded to hearing. Your father appeared. It proceeded to hearing. Your father admitted on the record that the money was owed at the time of the hearing. You filed a motion or sought to have that reset for hearing because you were not able to be here and you wanted to stay the judgment, even though your father consented on the record to the amount owed, and you failed to appear. And I granted you an opportunity to appear today and present your case. You filed that motion back on June 22nd. I not only allowed you to appear today, but I didn't even require you to put any money in escrow at that time. And you have the audacity to not show up in court today. I had to call you and make you log into Zoom.
Yes, Your Honor, I'm sorry. My daughter she is sick. She's right next to me. She has been sick for 5 days with 103 fever. They don't know what is wrong with her. She is throwing up. She hasn't eaten. She's been in the hospital. Her fever will not go away. Her doctor wants
I don't discount that you have a sick child at home, but what my concern is, this is not the first time. This is not the second time. It's at least the third time in which you have failed to appear in court. And you have the option of appearing from your house, which you are doing right now. You're not in a hospital setting.
Yes,
not in the emergency
room. I
room.
missed one court date, and that was on June 7th. I've appeared at every other court date via Zoom. I have never missed any other court date besides the June 7th one. And I have been sick, Your Honor, because our immune systems are not well right now because of the situation with the mice.
Okay. I recognize that. If you're living in a house that's infested with mice, and I've seen the pictures, why don't you get out?
We're trying to get out. We did find a place, but that did not work out. It was not ready to move in and will not be ready to move in for a couple more weeks. There was a problem with them getting the house up to code before it was able to be rented. And there are really no other rentals in the area that suit my family size. I have applied to multiple houses. We've even tried to get into a 3-bedroom at this point to get out of here, but it is very hard to find a rental.
Okay. Your motion that you filed on June 22nd, which requested a hearing, was to modify the judgment for per diem stay beyond 6/21. Is that your motion? Okay. You stated that tenants had no intention to move by specified time granted, which was beyond the typical time period. They claimed hardship for the extinction and are now claiming again they need to be financially responsible for their extended stay. Additionally, escrow of $1,795 be deposited with the courts. I have a claim of appeal from Michael Petey. He's claiming an appeal or filing a claim of appeal as to the judgment. Is that correct, sir?
Yes, ma'am.
Okay. And you filed your appeal paperwork already?
Yes, ma'am.
I'll let you move forward with your appeal because you admitted on the record that you owed that money. So if you want to appeal what you admitted on the record, be my guest. Ms. Petey, what's your claim?
My claim is that Joseph had a list of things he had to get done in the house to get it up to code for the City of Lansing Code Compliance Office. He did not do anything on that list. He fixed 3 things and that is it. And then he signed that false affidavit and submitted that to the city just to receive a code compliance letter stating that he fixed everything, and he did not. And then he submitted that to the courts claiming he fixed everything. Because the original—
So you're saying he has a false code compliance approval notice is what you're saying?
Yes, and Everett will be back out here on Monday to do a safety inspection since Joe did not fix anything in the house. He fixed a few things and then lied and signed that affidavit stating that he fixed everything, and he did not. I have had an electrician come in and fix the problems. I've had a plumber come in and fix the problems that are going on in the house. And the electrical it's a severe thing, and he did not fix that. He didn't fix any of the foundation. He didn't fix the furnace. Nothing on that list from the code compliance office was done.
You're talking about the code compliance notice from May 19, 2023?
Yes.
That was inspected from May 19th, compliance due June 18th.
Yes.
Correct?
Yes, that is the compliance letter. When Everett came out to do the inspection, he found multiple things wrong with the house that needed to be fixed, that were in a violation, and he was given a date to fix them by, and he did not. Joe fixed a garbage disposal, a window, and a few boards out front. So I've been calling the code compliance office for weeks now, and I've not been able to get a call back from Everett. So I called back the code compliance office, and I spoke to Everett's supervisor yesterday because I was calling to file a complaint because he would not, Everett would not get back to me. And the supervisor patched me through to Everett, and I explained the situation, and Everett said he will be back here on Monday at 3 p.m. to do a safety inspection to make sure everything on that list was done, which it has not been. Nothing on that list has been done.
Okay, and so as it relates to the claim against Mr. Petey, you can proceed with your eviction or appeal because you, and I note here, did not dispute that you owed that amount, and so judgment entered based on that. Ms. Petey, you failed to appear, but you did submit documentation that you was in the hospital. I'm going to find good cause and that you have a meritorious defense related to the case and as it relates to the default, and I'll set aside your default.
Thank you, Your Honor.
Your matter will be set for a hearing. You said that code compliance will come back out when?
Everett from code compliance will be out here on Monday at 3 p.m. to do a safety inspection.
Okay, I'm gonna set it for a hearing. You need to appear in person because I need all of the evidence. You need to bring evidence of things that you paid for to get repairs. You need pictures to show me the conditions of the property that you lived in. You need to bring me evidence where you've been making complaints from the time that you moved in here about the condition of the property. I see pictures of the rodent infestation, which that in and of itself is quite overwhelming. But you need to bring any other evidence that you believe is going to support your claim as to why you are not responsible to the now over $15,000 in rent. Okay.
Yes, Your Honor. And my father does have an envelope that I did send with him today. It does have some pictures of the electrical sockets that were changed out. I could only get 2 changed out. And the
well, you have to present the evidence. He can't present evidence on your behalf. He's already made an admission, and he now needs to file an appeal as it relates to his. You were not present, and so the case that was filed against you was defaulted, but I'm setting aside that default. You can come and present your case. He can't present it on your behalf, okay?
Your Honor.
Can I have a new hearing date?
It'll be July 18th at 2:30.
July 18th at 2:30 is your new hearing date.
Okay, thank you, Your Honor.
Okay, and you're making a motion for escrow, is that correct?
Yes.
Okay. I'm denying your motion for escrow because I find it completely ridiculous, the amount of mice infestation in this house. I looked at the pictures and my skin crawled for weeks. So based on that alone and the fact that she's had to discard of so many things, at least based on her preliminary statements, as well as had to have money out of her own pocket to have people come in. I'm going to deny your request. And at this time, we'll address whether or not money is due at the time of the hearing on the 18th. Any additional matters today? Okay, we'll get you a copy of your notice to appear for your next court date for you, and you'll get a notice in the mail, okay, Miss PD?
Okay, Your Honor.
You're all set.
Thank you.
I hope your day at the meeting as you are.
I'm sorry?
Then I hope your day is as amazing as you are.
Thank you. Have a good one. What is this? This needs to go down to criminal. Okay, let's see, Wimberley is here. That's the guy who was in custody. Oh, he's in the meeting room with this attorney. Kajer's all set.
Hello?
Hi.
Hi.
Mr. Wimberley. Okay, Mr. Wimberley is represented by Mr. Goodrich. Mr. Goodrich, do you need to speak to him?
Yes, I do, Your Honor.
Okay, one moment. Is Ricky Evans here? Okay, Mr. Wimberley, you need to go into the breakout room.
All right, push join.
Yes, please. Okay, and then Mr. Easley's here with Elon Thomas. Okay, are we running an exam on that? Okay. So Selena and I were waiting for Selena. Let's see Selena. You didn't get it. You get my water bottle. I'm just gonna wait for the people in the breakout room before we start back.
Hello,
Hello, what's your name?
Patrick Hayward. I'm sorry I'm late. I've been sick, real sick. I got Crohn's disease, so. I know I look like shit. I apologize. I apologize for my.
Whoa. Don't use that language in my courtroom, okay?
I'm sorry. I'm sorry. I apologize. I'm sorry.
Okay.
I apologize.
Please find Mr. Abbott.
It's gone.
Okay.
Yeah, it looks like crap. I apologize.
You're supposed to be here at 8:30.
At 9:30, it said.
Patrick Hayward,
Yeah.
8:30.
Oh my gosh, I'm so sorry. Like I said, I've been real sick. I've been dealing with kidney stones. I got Crohn's disease. I apologize. No excuse. I know.
Okay, we need to find your attorney, okay?
Okay, thank you very much. Now that if you can look by the look at me, I can tell I don't feel very good. Face is all swelled up.
Supposed to be a default, but I don't think they submitted a default.
Again, I apologize for being late.
On the record in the matter of the people of the state of Michigan versus Elon Thomas, file number is 22-03546 FY council appearance.
Thank you, Honor. Joe Coltrader. on behalf of the people.
Good morning, Your Honor. Robert Eastern on behalf of the defendant, Mr. Lyle Thomas, who is present standing to my right.
Thank you. So, Mr. Thomas, today was the date set for a preliminary examination. Looks like the people are unable to proceed. Is that correct?
That is correct.
Okay, and they're making a motion to dismiss without prejudice. So the case will be dismissed today. However, the people do have the right to reissue the charge within the statutory time frame if they're able to proceed in the future, okay?
If I may, Judge.
Yes.
The defense will request that the matter be dismissed with prejudice. And the reason is because this has been adjourned 3 or 4 times based on an outstanding discovery request that was presented in our initial appearance and demands, again with a supplemental discovery demand March 13th, March 10th, discussed it March 17th, March 19th, and then again ultimately March 20th. This court adjourned it one last time. I have a series of emails, and I know that this is not on Mr. Courtrider. He was not with the prosecutor's office at that time, but Mr. Thomas has been heavily prejudiced by this. He's an 18-year-old. This interrupted his last year of school. He was unable to play on his varsity basketball team because this was pending. None of the adjournments were due to any action or inaction on his behalf. And I think it would be highly prejudicial for him to have to come back on this. Mr. Courtrider has informed me that it is the prosecutor's intention to refile the case. They've had ample opportunity to A, provide the discovery that's required, and B, to have their officers here.
I do see on January 19th that I had to find good cause to go beyond the 21-day timeline because discovery was still pending. And then on the 24th of February, the trooper failed to appear. And then on March 16th, I noted defense needs supplemental discovery. So it does look like each of the delays since January were on the account of the prosecution.
Mayor, I can't speak to the earlier delays. Obviously, I wasn't with the office at that time. I would indicate on the record that people do take guns and young people in this city very seriously. It would be my intention to refile this case. I can't speak to the discovery issues. I don't know what was provided earlier and what wasn't. I know that all the discovery we have has been provided. This time I do not have my trooper here. I'm not sure why they're not here. So I would ask you to not dismiss it with prejudice at this time.
I believe that under the circumstances, and I'm not sure why the trooper's not here either, but this is not the first time in months the troopers failed to appear. I also see on April 20th, there were still issues that relate to discovery. So I can decide with the defense that there is or has been an extreme prejudice to the defendant in this matter, and that it's not provided him an opportunity to have his right to a speedy trial because he can't even get past the preliminary examination stage, and that's not on any part of his own. Looks like he's appeared for each and every court date. We're ready to proceed. So I'm going to grant the defense motion at this time.
Thank you, Your Honor.
Thank you. What is this? Okay, Mr. Goodrich, are you ready to proceed?
Yes, Your Honor. Mr. Wimberley would like to do a plea in this matter.
Okay, we're on the record in the matter of the people of the state of Michigan versus Keith Wimberley Jr., file number 23-01411 at 5. Council appearance.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
And Luke Goodrich from the Public Defender's Office filling in for Sarah Donnelly today and representing Mr. Wimberley.
Thank you. Today was the date and the time set for a probable cause conference. You said that there's going to be an entry of a plea today.
That is correct, Your Honor.
Okay, what was the offer?
Your Honor, at this time, the people are conveying the offer of larceny between under $200, under $753, $565, and that would be a 93-day misdemeanor and/or $500 fine.
Okay. Okay, added count 2.
Would be dismissed. And count 2, count 1 be dismissed. Yes.
Thank you. Okay, Mr. Wimberley, you understand that offer?
What was the offer?
The offer is for you to plead guilty to an added count 2 of larceny under $200. So that's a misdemeanor. The maximum penalty is 93 days in jail and/or $500 in fines.
Yeah.
You understand that offer?
Yes.
And you want to accept it?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can put your hand down, sir. Okay, Mr. Wimberley, in order to accept that offer, I need to explain to you your rights that you would have to give up. You have the right in this matter to proceed to trial. You have the right to jury trial. At the time of your jury trial, you have the right to the presumption of innocence. So you're considered innocent until the prosecution can prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at trial. You also have the right to see, hear, or question any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses to a trial or present evidence at trial that you believe show a defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. Do you understand all of those rights?
Yes.
Okay, and are you willing to give up each of those rights today to accept the offer and plead guilty to larceny under 200?
Yes.
Is anybody threatening you to get you to waive your rights today?
No.
Has anybody made any promises to you if you waive your rights?
No.
Are you currently on probation or parole?
Probation.
Okay, which court are you on probation for?
Mason.
Okay, 55th District?
Yeah.
Okay. And do you understand?
Excuse me, Your Honor, Mr.
Mr.
Wimberley,
Goodrich?
did you also tell me that you were on probation with the 56th District Court in Eaton County? I mean,
Yeah.
The Circuit Court in Eaton County?
Yeah.
Okay, Mr. Goodrich, did you discuss whether or not this will have impact on his probation status?
We did not get into that extensively, but I believe this occurred after his Eaton County matter, as he's already on probation for that.
I thought I was on the same.
I'm sorry?
I said that it was Eden. Mason was out Hope.
Okay, so do you understand that because you're on probation, that entering a guilty plea could possibly affect your probation status in those cases?
Yeah.
Okay, and you still want to waive your rights and plead guilty, understanding that?
Yeah.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you might need to report this conviction to a future employer. Do you understand that?
Yeah.
You also may have a conviction, or this may result in a conviction that may impact travel or immigration status that you may be seeking. Do you understand that?
Yeah.
Okay, and as to the added count 2 of larceny under $200, how do you plead, sir?
I plead guilty.
Are you pleading guilty because you believe you're guilty?
No. I was off a lot. I was going through a lot of things.
Okay, so you do not believe you were guilty?
Yeah, I believe I'm guilty.
Okay, can I have a factual basis?
Yes, Your Honor. Mr. Wimberley, do you recall March 26th of 2023?
Yeah.
Okay, and do you remember being at a location at 5016 South Martin Luther King, commonly known as Saldan's?
That's what it's called.
Yeah.
But yeah, I guess.
Do you remember being there?
No, but I guess I remember not being stable and doing things that I wasn't supposed to be doing.
Okay, well, when I spoke with you a few minutes ago, you told me you remember that day. Do you no longer remember that day?
I remember, but I didn't do it to tend to do it. I was on a lot of things.
Okay, I understand you were having some mental health issues, but do you recall being at that location?
Yeah.
On March 26th?
Yeah, the pet shop.
And is that place located in the city of Lansing, the county of Ingham, the state of Michigan?
Yes.
And do you remember going into that business and taking a jar of change off the counter?
I guess, yeah.
Well, you do?
Yeah.
Okay, and do you remember leaving the leaving the business with the change in the jar?
Yeah,
And you didn't have permission to take that jar of change, did you?
no,
And that jar of change did not belong to you, correct?
yes,
Well, so that, okay, so yeah, correct, that it's not you, was not yours.
right,
Your Honor, I believe and that the value of that money was worth less than $200, correct?
yes, way less. I
Alright.
remember, I remember just doing something I ain't supposed to be doing, and I was off for a whole lot of drugs, and I wasn't taking my medication, so I don't remember a lot.
But you do remember that there was a jar of change that you took?
Yeah.
Okay.
Since
Your
they
Honor,
told me,
I
yeah.
believe we do have a factual basis for larceny under $200.
Mm-hmm. Any questions from the prosecution?
No questions at this time.
Okay, the court is satisfied with the factual basis. I'll accept your plea. The finding to be made freely, voluntarily, and intelligently. There was no restitution, correct?
I know that there may be some restitution. I believe there was some money. We're not sure how much money was in there.
Okay.
It was a donation jar.
Got it. Well, we can set this for a hearing. Are we requesting a restitution hearing?
And I'll see if we can find out.
We'll set it for sentencing and restitution hearing. You said he's already on probation at 55th and 56th at this time?
Yes, he's currently doing a 90-day plus tri-cap program as part of his probation out of 56.
Okay, can I have a date for restitution hearing and sentencing? July 20th. July 20th? Yeah. July 20th at 8:30. Any additional matters for the record today? No.
Your Honor, I just would ask that Mr. Wimberley be allowed to appear over Zoom from tri-cap at that time as well.
That is allowed.
Nothing
Okay, you're all
beyond that.
set, Mr. Wimberley.
Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Let's see.
I believe we had Mr. Evans scheduled today. He kind of appeared.
Yeah, I issued a bench warrant. And then I see
You're all done, Mr. Wimberley.
Mr. Bisby's background. Oh, okay. And then Mr. Abdi didn't respond. Correct. Okay. Mr. Hayward, we're gonna require you to appear on July 14th, okay? You're muted, sir.
Yes, I agree. Yes, I appreciate you rescheduling me and not issuing a warrant. Again, I apologize for being late. There's no excuse.
Okay, make sure you're here July 14th at 8:30.
At 8:30 a.m. I will be there.
Thank you.
Thank you very much.
I didn't see a default. The objection is. Let's see.
Oh, it's coming up.
I'll talk.
Oh, are we ready for Mr. Bisby? Okay, we're on the record in the matter of the people of the state of Michigan versus Damon Rashad Bisby, file number 23-00863 FY, council appearance.
Your Honor, Dale Coulter on behalf of the people.
Morning, Your Honor. Attorney Derek Getzler, and also public defender on behalf of Mr. Bisby. I'm here physically in the courtroom. Mr. Bisby is appearing by polycom from Union County Jail.
I believe we're leading this out.
Okay, we're gonna continue to exam.
Yes, Your Honor.
Okay, this matter will continue to exam July 14th at 9:30. Any additional matters?
Your Honor, I would advise the court that he does have some mental health issues. I already told him to get stay to the jail. And he has some pending misdemeanor in South Carolina that's coming up for a court date around July 14th. I've given his family in South Carolina the number to the court and the number to the jail to provide his public defender there to try to see if he can appear by video. But other than that, nothing further, Your Honor.
Thank you. That will be noted in the file. Do you have any questions today, Mr. Bisby?
No, ma'am.
Okay, we'll see you next week, sir.
Yes, ma'am.
Thank you.
Your Honor.
Thank you. Have a good one. Yeah.
Thibodeau was a bench warrant, right?
Yes.
For whom?
He was asking about Thibodeau.
Oh, no, she never appeared.